Good morning. I'm Judge Ryan Sullivan. I'm going to be conducting the hearings today. And before we begin, Mr. Lucia, are there any cases you'd like me to turn to early on in the docket today?
None from the state's perspective, Your Honor. Thank you very much.
From the defense, are there any cases you'd like me to turn to early on this morning?
No, Your Honor.
All right, I'll just go down the Jill's list then. We have a first appearance for Kenneth Decker. Good morning, Mr. Decker. Probable cause has been found in this case, and I need to ask Mr. Decker some questions to see if he qualifies for the public defender's office. Mr. Decker, do you currently have a job or any income that you're making?
No, ma'am. I was working on getting my SSI from a bit.
Okay, no problem, sir. I will appoint the public defender's office to represent you. They'll be with you from here on out. Let's start the bail hearing with the state.
Thank you, Judge. The state's asking for a nominal bail amount of $2,000, bondable with pretrial services, supervision, and testing for alcohol, drugs, and paraphernalia. The nature of the allegations against Mr. Decker are not ones involving community safety or risk. However, he has a very difficult compliance history. He scored out as a 14 on the risk assessment. He was arrested pursuant to an FTA warrant where they found methamphetamine pipe in his possession, but the rest of his history is similar. In 2025, for example, he had a misdemeanor conviction for drug paraphernalia. And then in the Reno Justice Court, out of that case, there were 3 failures to appear. The rest of his history is of similar allegations, failing to register, despite a requirement that he do so. He's been convicted twice of that felony, all the way back in 1998, and then again in 2017. So compliance has been a long issue for Mr. Decker, and the state feels some form of monetary bail isn't appropriate to hopefully get him back on track and to take these court appearances seriously.
For the defense?
Your Honor, Mr. Decker, there's no amount of money that he could afford. We are going to be asking for an OR release today. He has lived in Washoe County his entire life. He does have an address at Dinslow Way that he is staying at. We know that pretrial services was unable to verify it, but he does have somewhere he can stay. We were able to speak to his mother on the phone this morning, who has a phone number that Mr. Decker could use to communicate about his court dates. Given the nature of the allegations in this case, we would submit that testing through pretrial services would be sufficient to ensure the safety of the community. And again, given that he does have some form of phone contact in a residence, that he would be able to appear for court.
So the concern for Mr. Decker is his history of failing to appear. He has a recent failure to appear and many in his history, and he also scores a 14, which is very high on the risk assessment. So in order to ensure he appears for the case, I think monetary bail is necessary. I'll set it at $1,000. That's bondable or 10% cash with Reno Justice Court monitoring if he posts. Thank you, sir.
Oh,
Next, we have a first appearance for Joshua Alexander Duran.
pull that back in.
Could we actually trail Mr. Duran? He is not here yet.
All right. Do we have Christopher Guerra?
Yes.
Good morning.
Good morning. In this case, a probable cause has been found. I need to ask him some questions to see if he qualifies for the public defender. Mr. Guerra, are you currently working or do you have an income of any kind?
Yes, ma'am, I do work.
Okay, how much money do you make per week, sir?
That depends. If I work a full week after taxes, I bring home about 1,300.
And how many people are in your household?
I currently just live by myself. I have a roommate and I have an 8-year-old son I also take care of.
Okay, tell me a little bit about what kind of bills you have and liabilities.
I pay my car insurance. I pay my car because it's still being financed, and then I pay rent and also just food and stuff like that.
And support for your child?
Yes, sir. Yes, ma'am. I mean, yes, ma'am.
Okay. Sir, have you used a public defender in the past?
Yeah, every time I've came here, I've been acquitted. This is the first time I get a good job to even
Okay.
yeah, but I do get a public defender every time I've been in here.
All right, so given his bills and liabilities and the fluctuating nature of his income, I will appoint the public defender to represent him. They'll be with him from here on out. I see he also may have another open case with the court right now. So let's start the bail hearing with the state.
Thank you, Your Honor. The state's requesting that the court set Mr. Guerra's bail at $50,000 with no 10% cash option, subject to conditions that he have no weapons, be subject to random testing for alcohol, drugs, and paraphernalia, and submit to pretrial services supervision. The allegations here are that he was caught with a firearm in a bag. In addition to that, there was a couple bags of methamphetamine that I believe were also one in the center console and one in a wallet. Sorry, it was paraphernalia. There was a trace amount of a white powdery substance in there, I should correct myself. From the PC sheet, the defendant indicated he wasn't going to challenge or contest his possession of a firearm, leading the state to believe that the likelihood of conviction is quite high for the most serious charge. He's a 12 on the risk assessment, which is higher on that instrument. Curiously, he indicated to pretrial that he had no fixed address, he was unable to remember his phone number, and declined to provide a reference. To pick up where the court left off, there are several active cases for which Mr. Guerra is currently pending. One of those is a conviction from June 2nd of 2026 for destruction of property. Excuse me, I said conviction. I meant to say an arrest. On June 2nd, he was alleged to have shattered the window of his ex-girlfriend's vehicle with a hammer. He was posted bail on June 8th, and the bail amount was $5,000 bondable. That case is still pending. He's got a misdemeanor conviction for failing to register as a convicted felon on February 11th, 2026. He was granted probation on that charge from the Reno Municipal Court with a clause for no drugs or paraphernalia. In 2025, he was convicted of a gross misdemeanor offense for conspiring to possess a firearm by a prohibited person. In 2024, he was convicted of a misdemeanor charge of domestic battery. In that case, there was a failure to comply note, as well as his probation being revoked that same year, 2 years ago. He also was convicted of violating a domestic violence protective order. He was ultimately given probation for that case on December 19th, 2024.
Why is it going so back in my history?
Yeah, so there's a revocation that was ultimately issued on that case on June 17th, 2025. He was reinstated to probation. There was another revocation hearing on that case on February 11th, 2026.
Well, what does that have to do with what I'm here for right now?
So I'll get to that in a second, sir. In 2022, he was convicted of a felony charge of attempted battery by a prisoner, for which he went to prison. In 2022, another gross misdemeanor conviction for unlawfully taking a motor vehicle. And then in 2018, a felony conviction for robbery with the use of a deadly weapon and eluding. That case ultimately resulted in parole violations, and Mr. Guerra's parole was revoked. So based on his criminal history, Your Honor, the state's got concerns about the defendant's inability to refrain from criminal conduct, which, as the court knows, is one of the things that we're instructed to consider when deciding whether or not to release a person on an OR, and what conditions the court should impose to make sure that they abstain from criminal conduct and no longer possess weapons or pose a threat to the safety of the community. Given my concerns about Mr. Guerra's future based on his past, I think that some form of monetary bail is necessary and was submitted on those recommendations.
For the defense.
Your Honor, we would request an own recognizance release or a lesser amount of monetary bail than that requested by the state. Mr. Guerra was born and raised in Washoe County. I recognize that pretrial services was unable to verify his information. We have spoken to his girlfriend this morning, who has verified that he does have an address at 401 Linden Street. He's been there for at least a year. He's employed as an electrician for the local union. And she also was able to verify us his personal cell phone number. So Mr. Guerra recognizes that he has had some issues with law enforcement in the past. However, he has really been taking the steps to get his life back together and to do what he needs to do to support himself and his family. His girlfriend did give her assurance that she believed Mr. Guerra would reappear for court. Again, that 12 on the MPRA, I think given what we verified, would be closer to the moderate range. Mr. Guerra does not have any FTAs or did not score points for any of those in the last 2 years. given all of that, we would submit that drug testing and a no weapons clause would be sufficient to protect the safety of the community and to ensure his return to court.
Can I speak before you make a decision, ma'am?
That's up to your attorney, sir. Everything you say
Um,
here can and would be used against you in the future.
Yeah, I understand that. I know I got a lengthy history, and the DA is gonna obviously tell you everything I've been charged with. Um, I know the charges I'm dealing with right now don't look the greatest. I've been going to court, ma'am. I know. I've been going to court for the previous charges. I have no FTAs. I mean, I work 6 days a week. If you guys put any type of, I'm willing to do drug testing. I'm willing to check in twice a week. Whatever you guys put on, I just need to get back to work, ma'am. And this is not somewhere that I want to be. I mean,
So I understand all those things. And I hear you, but this is the situation. You're already pending another case. Your
yes, ma'am.
criminal history is extensive. You score
Mhm.
highly on the risk assessment. This allegation is you had guns and drug paraphernalia when it's pretty clear
Yeah.
you're absolutely not supposed to have those things.
Yes,
And
ma'am.
I see, counsel, that there's a revocation hearing set on Monday morning in RCR 2026-135865. We'll keep that for Monday. I want to make sure I have time to review that matter as well. But on this case, I have no choice given the circumstances but to set bail. I'll set it at $40,000. It's bondable only. And if he posts supervision by pretrial services, testing for drugs and alcohol, and no weapons.
So
We'll
is
have
that
the other hearing
10%
on Monday.
vulnerable?
It's not.
It's not 10%. So it'd be what, 45?
I contacted them.
That's on
Right,
board.
next let's turn to Lyric Monsois Richardson. Good morning, counsel. There are two cases here. We need to set two different bails until and unless they're combined. Probable cause is found on both. Public defenders appointed on both. Let's begin with the state for the bail hearings.
Thank you, Your Honor. I'll begin with I don't know if this is the older case. I'm just calling it the warrant case. These are the allegations of the discharge of a firearm and reckless endangerment. On that case, the state's requesting that the court keep the bail as set in the original warrant, which was a $30,000 bail with conditions to include supervision and no weapons. The concern from the state's perspective is one of community safety in this case. The allegations are that in the midst of a heated argument while allegedly intoxicated, the defendant fired off a round. From the probable cause declaration, it looks like minutes before the shooting, there was a toddler in the area. So this is a situation where there is a congested area, obviously increasing the risk to the community. He scores out as an 8 on the risk assessment. Notably, and most concerningly to the state's perspective, is that there's a pending case in the Second Judicial District Court. He was unsuccessful in supervision in April of 2025. There was no listed employment, no income. He declined to provide a reference. And with respect to that 2024 pending second JD case, Your Honor, he pled guilty in March of 2025 for possession of a stolen firearm. Ultimately, a bench warrant had to be issued in that case for failing to comply with conditions of his release. There's a note that might have been an FTA for sentencing, but I'm not 100% sure on that. I know for sure that there was a bench warrant issued for failing to comply with conditions from the second JD. And so based on that history, the state's got concerns about ongoing risk, about flight risk as well. And then to dovetail into the quote unquote new case, these are the allegations related to vehicle burglary and possession of a motor vehicle. The defendant was, while having a pending case in the second JD, observed in the company of a co-defendant, Mr. Watts, essentially wandering through an apartment complex parking lot at 3:30 in the morning with flashlights looking into vehicles. What they found inside the vehicle that the defendant indicated he was sleeping in was some mail that belonged to other people, as well as property that was taken from several vehicles there. So in that case, the state is requesting a $20,000 bail with conditions to include no contact with the listed victims, as well as the address of the offense, which is 1680 Sky Mountain Drive. The listed victims I had is Anna Chandler, Robert Clark, and Larry Butts. And also that he had no contact with the co-defendant, Mr. Watts, and not possess any weapons, again, related back to his other allegations and subject to supervision. In a short amount of time, the defendant's amassed 3 total cases. He's got a rocky compliance history, which caused me concerns about his being both a flight risk and a risk to the community.
For the defense?
Your Honor, we would note there is that second JD case that has the $10,000 cash only bail. We're not objecting to monetary bail in these cases, but we would request in the alternative for an OR to a treatment program. If you look at Mr. Monsieur Richardson's criminal history, there are some drug-related charges present. I believe that may have played a factor in getting him to where he is today. So we would ask for that alternative OR to treatment, that in the event Mr. Richardson, he does have it was a failure to appear for sentencing. He will have a sentencing in that second JD case if by chance he is able to successfully argue for a program or a treatment court or a grant of probation, that he could be OR'd so that he could go to a program in these cases as well.
Well, I think it's premature at this point, given all these allegations and the potential harm to the community that could have resulted, particularly with discharging that weapon outside of the apartment complex where the toddler had just been relatively recently and not showing up for a sentencing. So at this point on the case, it involves the stolen vehicle and the other allegations. The bail will be set as the state requests $20,000. No contact, Anna Chandler, Robert Clark, Larry Butts. No weapons, pretrial services, supervision. And then on the case that involves a discharge of the weapon, it'll be $30,000. Bondable or 10% cash. Both of these are bondable or 10% cash. Same conditions as far as pretrial supervision, no weapons. And Mr. Lucia, did you ask for testing for drugs or alcohol or not?
I did not, Your Honor. I didn't see, other than an allegation in the discharging case that he was allegedly drunk, I didn't see anything.
Right. All right. Well, again, he also has the cash bail in district court, so this is likely academic. So I'll leave the conditions as I stated. Thank you. Next, we have a first appearance for Anthony Watts. Good morning. Probable cause has been found. The public defender is appointed. Let's begin the bail hearing with the state.
Thank you, Your Honor. The state's asking similarly for $20,000 with this exact same conditions as in Mr. Monsoor's case for Mr. Watts. The facts are relatively the same. The MPRA is approximately the same. Mr. Watts scores out as a 9, which is higher on that document. He's only been in Reno for 2 years. He has no fixed address, is unemployed, and was unable to provide a reference, which suggests he's got relatively shallow ties to our community. With respect to his prior criminal history, there's a 2026 misdemeanor conviction for possessing drug paraphernalia, for which he was given credit for time served on June 23rd, 2026. So just recently, probably just about a month ago, he was released on that charge. And then that same year, this year, he has a misdemeanor conviction for possession of a drug paraphernalia and driving on a revoked license. That case came from the Reno Justice Court and indicated that the defendant had failed to appear for an MSC. And he's got a 2025 conviction for misdemeanor DUI. So given the recent history that the defendant's amassed, in addition to that, he was relatively uncooperative with the police in this case. When they contacted him, he told them that his name was Bobby Boucher, which is obviously not accurate. And I believe, if I can have 1 second of the court's time. Yes, the only difference I would be making in terms of my request for conditions as it relates to Mr. Watts is that he not possess or consume any alcohol, drugs, or paraphernalia. That's based on his 2026 paraphernalia conviction, as well as that 2025 DUI. But given his relatively minimal ties to our area, his passing of now 3 cases in the last 2 years, and that recent FTA, I've got concerns about his flight risk.
For the defense.
Thank you. Mr. Watts is going to be asking for an OR release. There is no amount of cash bail he could afford at this time. I would note that reviewing his criminal history, he has no felony criminal history. he does have some ties to the Reno area. He has lived in Reno for the past 3 years, he reports. He has friends with whom he could stay. He's previously worked in construction and is actively looking at getting a new job again. He does have a phone number that was verified. And so with the appropriate pretrial services, supervision, and drug testing, we believe that given his much more minimal criminal history, Mr. Watts would reappear for court and would not be a flight risk or danger to the community.
I hear he was just convicted last month of a case involving drug paraphernalia, and he scores a higher risk. This is an escalation in criminal activity. I believe it warrants monetary bail pursuant to the risk to the community, but I'll set it at $10,000. That's bondable or 10% cash. No contact to Anna Chandler, Robert Clark, Larry Butts. And if he posts that, he'll be supervised by pretrial services, no weapons, and tested for drugs and alcohol. Thank you. Next, we have a bail hearing and arraignment for Austin Dyer.
And Your Honor, Mr. Dyer was not transported for the hearing today. I believe he's a special transport. I have not gone over the criminal complaint with him, so I would ask if we could reset his arraignment. I am prepared to make an argument on bail.
All right, I'm happy to go forward with the bail and we can set the arraignment out as needed. Let's start the bail hearing with the state.
Thank you, Your Honor. The state's requesting that the $6,000 as originally set on the warrant remain. Mr. Dyer has a very troubling history with respect to similar allegations. Notably, he's got a 2025 case for damage to jail property. He was convicted that same year for the felony crime of battery by a prisoner in a case in which he was alleged to have been combative with folks up at the jail while in possession of a modified shank. I also show that in 2025, there was a felony arrest for coercion with physical force. Likewise, out of the Second Judicial District Court, he's a 2024 felony conviction for burglary of a motor vehicle. He was on probation for that charge when he picked up those other offenses that I mentioned. He's got a 2024 gross misdemeanor conviction, for conspiring to commit burglary, which he was also afforded probation for. I just would note this isn't the first time that Mr. Dyer is facing these kinds of allegations, been convicted of them previously. And anytime I see violence, particularly violence when somebody's in the most supervised place on earth, I've got concerns about what they would do if they were out in the community. So for that, I think the $6,000 is extraordinarily reasonable.
For the defense.
Your Honor, Mr. Dyer was just transported here from NDOC where he did serve a sentence for, I believe it was the battery of the 2025 battery by a prisoner. This case actually relates to conduct that occurred last summer, shortly before Mr. Dyer was transported to NDOC. So he has had 11 months at NNCC where he has been participating in programming. He has met with his parole officer. He very much wants to comply with the conditions of parole and would like to be OR'd to a program with respect to these cases. And I would submit based on that.
I just need some more information before agreeing to do something like that. He was just brought straight from prison. I have some concerns. Obviously, he's got a long history of violence and there is a risk. So I'm going to keep the bail as set. And then when would you like to set his arraignment for?
Monday would be fine.
Okay, let's set his arraignment for Monday morning then. Next, we have a first appearance for Delvin Holmes. Good morning. In this matter, sir, you've been arrested due to the allegation of being a fugitive from another state. So I find there's probable cause for that. So once your criminal complaint's filed here, we'll bring you back to go over what choices you have and what rights you have in Nevada. Thank you.
What?
That means that they'll get the paperwork.
Next, we have first appearance for Alfonso Rubio.
And Your Honor, Mr. Rubio would waive his appearance and I'll submit on the state's argument. He has a parole hold.
All right, your request for bail then, Mr. Lucia, given the submission?
Your Honor, it would just be $5,000. He's picked up a slew of recent cases and is paid on the risk assessment.
All right. So it'll be $5,000. That's bondable or 10% cash. I assume he's got other conditions associated with his other matters, so I won't impose any other conditions here. Next, we have, how would you like me to turn to the cases? We have Axel Lopez and then we trail Joshua Duran.
Your Honor, I'm prepared to argue on Duran. I've confirmed that he would like to waive his physical appearance this morning.
Okay. Sorry, counsel, I'm on call. Could you give me just a moment to answer a telephone call from law enforcement? All right, I apologize for the interruption. And Ms. Riley, I did not hear what would you like me to do? What order would you like me to call?
Either order. I'm whichever the state would prefer first. We do have Mr. Lopez present.
Yeah,
All right, let's go forward with the one that's present first, Axel Lopez. Good morning. In this case, a probable cause has been found. The public defender is appointed. Believe this is an ad book allegation. Let's begin the bail hearing with the state.
Thank you, Your Honor. The state's asking the court set Mr. Lopez bail at $100,000 with no 10% option given the nature of the allegations. This case sort of stems from an original case where Mr. Lopez was caught effectively trying to procure nude photographs from an undercover officer posing as a 15-year-old child. Further exploration into his cellular phone reveals extraordinarily disturbing images that I will not repeat for the record, with victims as young as 3 to 5 years of age. The PC sheet outlines that the 20 videos that were specified represent, quote, a small portion of the suspected CSAM located during that investigation. He's got that pending case for attempting to use a minor in the performance of a sexual portrayal, which carries a significant prison sentence to it if convicted. And he's got a 2011 entry for a misdemeanor conviction for minor in possession and obstructing or resisting, easy for me to say, which resulted in a probation violation arrest. So I would submit his history is relatively antiquated. However, the recent 2 cases that bring him before the court are extraordinarily concerning to the state. And this is not a result of just one minor lapse of judgment, but rather suggestive of a more deliberate effort to conscientiously obtain as much of this horrific material as the defendant can get his hands on. So given the fact that he's likely to be convicted of these charges from my vantage point and sentenced to prison for such, I submit that he is a flight risk and some form of monetary bail is necessary. As conditions go, I would ask that he not possess any alcohol, drugs, or paraphernalia. In that underlying pending case, Judge, he was caught with methamphetamine as well as Xanax. That he have no electronic devices, and that he submit to supervision.
For the defense?
Your Honor, we would submit that the $10,000 previously set in the prior case is sufficient bail for Mr. Lopez and would ask that the court not impose any additional bail with respect to these charges. Again, the cases are closely interrelated. This relates to material that was found on Mr. Lopez's phone after he was already arrested in the prior case. He has not been able to make that $10,000 bail. Clearly, it is sufficient to keep him here at the jail, and we would submit that no further bail is necessary.
I believe what this case shows is in investigation, things are far more serious than perhaps even estimated at first. These are some of the most horrific allegations against very vulnerable children in I think that represents a huge risk to our community. So bail will be $100,000 bondable only. For this case, I'm just going to indicate pretrial services supervision. He has all the other conditions attached to the other matter. Thank you. Let's turn to Joshua Alexander Duran.
Thank you, Your Honor. So in Mr. Duran's case, the state's asking for $150,000 with no 10% option given the nature of the allegations. This began as a robbery where Mr. Duran, in the company of a co-defendant, effectively took some merchandise, and Mr. Duran shoved his way out, knocking the clerk out of the way in order to make away with those goods. While being surveilled for arrest on that robbery charge, law enforcement ultimately contacts him. He flees on foot before essentially getting into a physical altercation, which officers then later realized the defendant was armed with a knife and was essentially trying to stab or slash two law enforcement officers. He indicated to the police that he was hopeful, the defendant, that the police were actually going to kill him, which is indicative of a person who essentially has nothing to lose and thus only exacerbates the risk he poses not only to the community, but his almost certainty of flight or criminal conduct. With respect to his prior criminal history, it's replete with convictions for similar offenses. He's got a 2021 felony conviction for burglarizing a business. That case originally began as a robbery, where the allegations were that he was swinging a set of pliers at a loss prevention officer at Best Buy in order to steal merchandise. That case he picked up while on own recognizance release for allegations of assault with a deadly weapon, battery with a deadly weapon, destruction of property, and domestic battery. In that case, he was ultimately convicted of battery resulting in substantial bodily harm, rejected from the mental health court because of his criminal history, which continues in the year 2021 for obstructing and resisting, as well as a trespassing case, which resulted in an FTA and a contempt. He's got 2019 convictions for possessing drug paraphernalia, likewise had an FTA, 2014 felony conviction for burglary, in which is dishonorably discharged from parole, more obstructing conviction in 2013, another felony conviction in 2012 for attempted burglary. That was pled down from residential burglary. He was granted probation. His probation was revoked. He was granted parole. His parole was revoked. He's got a 2011 gross misdemeanor conviction for possession of a stolen motor vehicle. He was given a known recognizance release, failed to appear, and then he's got another felony conviction from 11 for grand larceny. So theft and violence are nothing new for Mr. Duran. If anything, it's only escalated in terms of severity, which causes the state extreme concern. So if he was able to post bail, the conditions that the state would request would be no contact with Susie's adult bookstore, or the listed victim is Kimberly Elias. I believe it's also Kimberly Conklin, so same person, new last name. No weapons, subject to alcohol, drug, and paraphernalia supervision testing. I would also submit that he submit to house arrest or impose a GPS if he does post bail, given the extreme nature of my concerns about the risk he poses to the community as well as flight.
For the defense?
Your Honor, Mr. Duran would be requesting bail in the amount of $10,000. He's lived in Washoe County his entire life. He has a current address that has been verified by pretrial services. He's also been working at the UPS warehouse as of fairly recently. He would like to be able to return to that job. He did serve in the Army from 2010 to 2011. He believes there are some services that if he were to be released that he could pursue with his status as a veteran. We have verified that. We've spoken to his mother this morning, who says that he is a reliable person, but has had some struggles recently, especially as relates to mental health, which again, she believes he could get treatments for through the VA. Given all of that, we would request that $10,000 bail.
His criminal history is extensive, and he also, as far as the robbery goes, it appears it was relatively thought out, as given by the PC sheet of the two arriving together and then one leaving before and then the other picking him up in the parking lot. So I am very concerned about risk to the community. I will take into consideration that there was no weapon used during the robbery. I'll set the bail at $60,000 bondable only. No contact with Susie's adult bookstore or Kimberly Elias. If he posts, he'll be supervised by pretrial services, no weapons, and tested for drugs and alcohol. Thank you. All right, council, I believe that was it for the morning. Anybody I missed or any clarifications needed?
That was everything I had, Judge.
All right, thank you all. Have a good day.
Appreciate it, Your Honor.